Okay, great. Well, I think we have a quorum here, so we're going to go ahead and get started. And I just want to start off by thanking you all for joining us today. I'm Adam Kavakovic. I'm the CEO and founder of Chamber of Progress. We are a center-left tech industry association. And as our country grapples with this question of how to stop white supremacy, hate speech, violence from spreading both online and offline, an important part of that conversation is about online content moderation. It's a practice which Texas's new social media law effectively now prohibits. I think, as most of you know, we're now less than a week after the U.S. Court of Appeals for the Fifth Circuit overturned a district court decision and allowed the new Texas social media law to go into effect. That was really a very stark departure from multiple recent court rulings that have affirmed platforms' rights under the First Amendment to moderate content. And again, I think, as most of you know, NetChoice and CCIA have made an emergency appeal to the Supreme Court. And Justice Alito has actually asked Texas AG Ken Paxton to respond to that appeal by the end of day today. Late last night, our organization, Chamber of Progress, and 19 other organizations, several of whom are represented on today's call, filed an amicus brief with the Supreme Court opposing Texas's social media law. And of course, we're also having this discussion just days after a tragic act of domestic terrorism in Buffalo, New York, resulting in the deaths of 10 Black Americans after the perpetrator both posted racist manifestos online and attempted to live stream the massacre through Twitch. And I think what's clear in the wake of this tragedy is that we must be doing everything in our power to stop white supremacist ideologies like the replacement theory from further radicalizing Americans. But that is in direct conflict with this law, with this Texas law, which explicitly prevents social media platforms from taking down user content, even when it promotes racism or terrorism. Our organization advocated against this bill before the Texas legislature last year. We worked closely with Texas Democrats to oppose the bill. But in the last couple of days, we've seen Texas Republicans, some of whom worked to pass this bill. They've tried to muddy the waters since this mass shooting in Buffalo. Just 2 days ago on Twitter, we saw attempts by the legislation's sponsor, Representative Briscoe Cain, to cover up the law's intent. And Texas Republicans promoted this bill as a response to alleged anti-conservative censorship, but they ignored warnings that their bill would also require platforms to carry posts filled with hate, harassment, white nationalism, domestic terrorism, Holocaust denial. And as one of our speakers will talk about, they even voted against carve-outs for those categories of speech. So as this law takes effect, we are really calling on Texas Republicans to take responsibility for enacting a requirement for social media to host harmful, racist, violent content, just as the country faces new, unfortunate violence. We're joined today by experts to share a little bit more about the legislative debate over the law's harmful impact on marginalized communities, and what to expect from the pending litigation moving forward. So first, we'll hear from Texas Democratic Representative John Rosenthal, who debated this bill on the floor of the Texas House last year and who offered amendments that would have allowed social media sites to continue to take down content related to terrorism and Holocaust denial. After that, we'll hear from Carlos Gutierrez, the Deputy Director and General Counsel of LGBT Tech. Carlos has spent years advocating for the LGBTQ community online and filed a declaration in this case about the impact that the law will have for online platforms that are trying to protect marginalized communities from hate speech and violence. We may also be joined a little bit by a representative from the National Hispanic Media Coalition. And finally, my colleague, Elizabeth Banker, who's our Vice President of Legal Advocacy here at Chamber of Progress, will speak. Elizabeth spearheaded the amicus brief that we filed late last night, again, which included a total of 20 organizations, including the NAACP, the Anti-Defamation League, Family Online Safety Institute, National Hispanic Media Coalition, and the families of victims of the Sandy Hook massacre. Elizabeth is an extremely experienced First Amendment lawyer, has spent years defending the rights of platforms to moderate content on their own platforms. And she's also an expert in Section 230, which is one of the foundational laws of the internet. So with that, I'd like to hand things over to Representative Rosenthal to share some comments and some perspectives on the debate over this bill in the legislature last year. Representative?
Thanks so much. Thanks, Adam. And I really appreciate being invited to this particular press conference. This is something that I have been particularly involved with, passionate about. So my name is John Rosenthal, and I represent an area of Northwest Houston, House District 135. And as a person with the last name Rosenthal, when we see the rise of hate and hate speech, alarming events like we saw the march in Charlottesville, where they were literally saying Jews will not replace us. In my area, I'm in Cypress, Northwest Harris County. This is a suburban district. And we had a group out here very recently calling themselves Aryan Freedom Network, putting out racist hate flyers on people's cars in parking lots and stuff. So, it's very alarming, the rise of hate in general, specifically hate speech, anti-Asian hate, anti-Muslim hate, anti-Semitic hate, anti-immigrant hate. It's all the same hate. So we're talking about this House Bill 20, where, as you said, the premise was to prevent censorship of conservative talking points on social media platforms. And of course, there really isn't censorship unless you're forwarding hate speech, which is clearly not protected by the First Amendment. For the same reason you're not allowed to shout fire in a burning shout fire in a crowded building. It's dangerous. And so we were trying to point this out. We not only debated the bill itself, but the amendments that I offered, and also Donna Howard, Representative Donna Howard from Austin, Travis County area, were in this fight, pretty engaged in this fight on the House floor. And the two amendments I specifically brought, one was about Holocaust deniers, anti-Semitic Holocaust deniers. But the other one that actually got a little bit of traction, I think I got 1 or 2 Republican votes, was domestic and international terrorism, and we framed the amendment as preventing the social media platforms from terrorist recruitment videos and advertisements. And I even said the words at the microphone, if you vote this amendment down, you're voting to support domestic terrorism, international terrorism, and their recruitment efforts here in the United States. And while I got groans from our membership on the House floor, they still pretty much voted down the amendment on party lines. So it's very alarming what folks are willing to do to line up with their party instead of what's just right and just. And right now we're seeing the effects of that. It's the particular danger is exactly what we talked about, is exactly what we're seeing right now. And we all have to be working together to fight against this sort of hate.
Thank you, Representative. It's super helpful to hear your perspective. Somebody was there, involved in the debate around this. I think it's this bill, this law is just now coming to a lot of people's attention who weren't following it last year, but you were a real leading voice in highlighting the consequences of it. And you talked about hate speech, and I think it is important to say, hate speech, harassment, a lot of these things actually are protected by the First Amendment, but they are not allowed by the platform's terms of service. That's where content moderation comes in. So to say, well, they should allow anything that's legal, that's not the point. There's all kinds of speech that is legal, but which platforms remove. And we want platforms to remove because that's what make these platforms a better place. And it's a really important point. Next, we'll go to Carlos Gutierrez with LGBT Tech. Carlos, love to hear your perspective on the law.
Thanks, Adam. So as Adam mentioned, I am the Deputy Director and General Counsel for LGBT Tech, and we're an organization that works around privacy issues, and 230 and this type of social media laws are something that's very important to us because we feel like the protections provided by content moderation for marginalized communities are something that's critical for communities like ours, the LGBTQ plus community, to thrive online. LGBTQ individuals and those that are struggling with the sexual orientation and gender identity often turn to social media sites first. We're one of the few minorities that are discriminated against, even in our own homes potentially. So a lot of youth and a lot of people who are figuring out their identity are going to social media sites before they even talk to their own families, because that's a place where they feel protected and may be able to have a safe space. These kind of content moderation rules that we're talking about here with HB20 and removing that would take away a lot of that safety for individuals that are going online to find safe spaces to access information and the support that's not always available in their communities. So content moderation on social media sites has always been a critical tool for ensuring the safety and the community of LGBTQ individuals. Without these policies, digital forums and apps can easily and quickly be overrun with homophobia, bullying, harassment, and misinformation. And content moderation is one of the tools that sites use to prevent or at least minimize some of these attacks on marginalized communities. We are very concerned that HB20 will make the internet, including the services and platforms that LGBTQ individuals use daily, unsafe to such an extent that LGBT communities will lose access to valuable and sometimes life-saving information that they would have access to otherwise. The law will inflict unique harms on LGBTQ individuals who rely on these content moderation systems to remove the worst of the worst content. In particular, the proliferation of such content is going to make it much harder for our groups to participate and communicate freely without being harassed. It also amplifies and risks amplifying homophobic and hateful stereotypes in myths and society more broadly. And we're seeing that currently on many different fronts. Furthermore, it could actually have even more serious consequences. If we're talking about issues like conversion therapy, which has been a fight that the LGBTQ plus community has been fighting for many, many years, despite conclusive scientific and medical research that shows it is dangerous for LGBTQ individuals, too many organizations and individuals continue to market conversion therapy as a cure-all for homosexuality and as a way to kind of come out of the gay lifestyle. Under this law, conversion therapists are able to promote and market these services without any pushback. Not only market them in their own spaces, they would have the ability to flood safe spaces, spaces that LGBT communities have claimed as their own to talk about these issues. People who are conversion therapy survivor groups, they are under attack by these kind of facts about the conversion therapy success rates that may be completely misleading. But for a parent of an LGBT youth who's being flooded with this content now, it may really lead to a false sense of conversion therapy's benefits and could really cause a lot of harm for teens that are looking at, their identity and their parents who may be thinking of this as a cure. So, but under HB20, platforms would have to leave this content up because it reflects a viewpoint, even though it's a really dangerous viewpoint for our community. And then, we've talked a lot about the issues that extend to online hate speech against marginalized communities as well. And there's no question that removing the content moderation under the HB20 standards would go way beyond protecting political speech. This isn't just about protecting political speech. This is about allowing content that, is hateful and is harmful. It protects and promotes hateful content that is neither liberal nor conservative, including anti-trans content that insists that transgender individuals are mentally ill or attacking age-appropriate gender affirming care for children in different states. It also kind of protects homophobic content that recycles stereotypes of gay men being social deviants who deserve to have HIV and promotes dangerous stereotypes of professional LGBTQ professionals like teachers that are being inherently predatory towards children. We have now currently seen an immense increase in this type of content surrounding the debate over the many states don't say gay bills, including the bill in Florida, where opponents of these laws are basically being called groomers and pedophiles because they want to ensure that kids that are young have age-appropriate content talking about sexual orientation and gender identity. And anyone that speaks in favor of these kind of clauses are against these laws is immediately being labeled like a groomer or a pedophile, which is like, an echo back to the 80s and the 70s, where this kind of discourse was very common online around same-sex marriage laws and education laws in the 70s. So everything new is old again, but this content has now come right back into vogue, and a lot of social media people are being flooded with this type of content for speaking out against these laws. Finally, we've also seen an increase in harassing and bullying content that uses anti-gay slurs and uses LGBT culture and sexual orientation as available weapons to degrade others. An astounding 68% of LGBTQ adults have encountered online hate and harassment, and 51% have been targeted for more severe forms of online abuse. By comparison, roughly 40% of straight adults have reported this kind of harassment. So it is definitely a problem that impacts marginalized communities in a much greater way. Thus, content moderation is definitely essential to protecting marginalized communities and reducing online hate and harassment. But under HB20, a user's hateful and harassing viewpoint is seen as valid, if not more valid, and is protected and prioritized over protecting marginalized users and prioritizing inclusivity. So that is a lot of the concerns we have with this bill, just off, as tip of the iceberg.
Well, thank you, Carlos. I think this is such a great, your statement is such a great reminder of what exactly this impacts, because again, a lot of these things you describe, conversion therapy, harassment against LGBTQ individuals, it's legal. But if you look at the content policies of many of the platforms, they have rules in place to take down that kind of content, and that's the kind of content moderation that's forbidden under this law. Finally, we'll go to my colleague, Elizabeth Banker. Elizabeth, can you walk us through what to expect next in terms of both the Supreme Court appeal as well as the litigation that we're likely to see from plaintiffs suing in Texas that their rights have been violated under this law?
Sure. Thanks, Adam. Maybe just to put our recent filing in context, when HB20 passed and became law, two organizations, NetChoice and CCIA, filed a challenge to the constitutionality of the law because of the restrictions it places on the ability of online services to remove exactly the type of terrible content that we've been talking about. A federal judge issued a preliminary injunction preventing the law from taking effect, and that injunction was appealed by the state of Texas. The Fifth Circuit recently heard oral arguments on that appeal, and after hearing arguments, they actually granted a stay to the state of Texas against the preliminary injunction the district court had entered without actually ruling on the substance of the appeal itself, which is a very unusual move and I think very unexpected. And so, what's going on right now is really an emergency response to the threat that HB20 poses if it is in operation. So right now, there has been an emergency application that is directed to Justice Alito at the Supreme Court. He has asked Texas to respond to that application. So in addition to the application itself and the many amicus briefs that were filed in the last couple of days in support of that application, we'll be hearing from Texas today. And then it'll sit with Justice Alito, who has choices. I think the best case scenario is that he would agree that it is astonishing and really dangerous for the Fifth Circuit to have granted the stay, allowing Texas HB20 to be in effect, and that should not happen until the law can be fully adjudicated. We're in a really preliminary position in terms of where we are for the litigation itself. There are a lot of legal issues with HB20 that haven't been fully litigated. So I think that would be, I think, the best case scenario. If Justice Alito declines to take any action, the plaintiffs here would be able to apply to a different justice on the Supreme Court. And Justice Alito also has the option of referring the matter to the full court. So we'll be watching to see what happens with that. In terms of what we expect to see with HB20 in effect, which it is right now today, we do expect to see lawsuits being filed by people who have had content removed, who are, under Texas law now able to bring private claims against service providers for violating this law. And I think many people think a private right of action, when it has injunctive relief, isn't necessarily as dangerous as a private right of action that enables large damages to be obtained. But I actually think in this case, it's far more dangerous, because what the court is essentially invited to do is to tell platforms they have to put back up these hateful messages and the people who are behind them and proliferating those messages. So I think we're definitely watching for that. We're also watching for Texas Attorney General Paxton, who also has authority to enforce the law, to bring actions. He has an investigation pending against Twitter, as well as other companies for deplatforming former President Trump. So clearly, this is something that, he's already taken action on once before. So it's definitely not a leap to think that he will do so again.
Terrific. Thanks, Elizabeth. With that, I'd like to open up to the floor for questions from journalists in attendance. We have a number on the line, some who've been following this quite closely, others who maybe haven't been following us closely, and we have a good cross section of experts here. So let me open it up to questions from journalists on the call. And no one, people are bashful. So I'll while we're waiting, Representative Rosenthal, I'd love to get your perspective on something. I think all of these concerns were raised against this bill when it came up last year, right? But the Republicans who pushed it seem to kind of be dissembling about it now, rather than kind of proudly defending the law. Does that surprise you?
It does some. I felt like on the House floor, we have quieter conversations sort of on the sidelines, and I know that a number of my colleagues, some of the conservatives, didn't like the content of this law, and the way that it goes is leadership priority items all get voted for, or those people are cut out in the next set of elections. So we had a number of issues come up like that in this last legislative session. And this was just one of those things that some of the more moderate conservatives, who incidentally may not be returning for this next session, didn't like it, but voted for it anyway, because it was a leadership priority item for them. And so they really don't have much choice about that in the structure of their conference and the structure of their caucus. And so I found it really concerning, especially during a time when we're seeing the rise of hateful speech towards all sorts of groups and some really extreme behaviors, and this just promotes that.
And I will say too, I mean, one of the things that's so somewhat surprising to me, or maybe I shouldn't be surprised, is that there continue to be copycats of this bill, of this law. Just this morning, Michigan legislature considered its own copycat version of the Texas law, right? Despite all of these concerns that have been aired. Let me pause here again and see if there's any questions from journalists on the line.
Hello, yes, I'm from the Texas Signal. I have a question for Ms. Banker. What's the likelihood that the case goes all the way to Supreme Court and then finds that the Texas law is actually constitutional and thereby could maybe affect social media platforms across the entire country?
Sure, that's a very good question. Definitely takes some prognostication. I think we'll see how this particular piece of the litigation plays out, but we are still waiting for the Fifth Circuit to actually rule on the merits of the preliminary injunction. There will be an opportunity, it is expected, given that they allowed this HB20 to go into effect, that they're going to say that the preliminary injunction should not have been granted. There will be an opportunity to appeal that. You can go to the Court of Appeals en banc, and from there it could go back to the Supreme Court for decision. It could also go back down. There are other issues with HB20 that haven't been fully litigated. The preliminary injunction is just the first step. The ultimate goal would be to get a permanent injunction against HB20. In terms of the possibility that it'll be found constitutional, I think in the end that is really unlikely. In the emergency application, the applicants, NetChoice and CCIA, did a really good job of explaining all of the tremendous First Amendment issues, and that the precedent, both in terms of what the Supreme Court has previously ruled, as well as what federal courts of appeals have been deciding in cases directly on point to this issue, is that providers have First Amendment rights to decide what type of content they do and do not want on their platforms. They're essentially being compelled to, have this really important speech on their platforms, and that just is not constitutionally supported. I would also say that there are a number of other constitutional issues, one of which you alluded to in the reference to, if the Texas law is upheld, does this become the law of the land? And, the thing is that states can't regulate the internet. It is a vehicle of interstate commerce, and Texas has really reached beyond its borders with HB20 in a number of ways. It purports to protect the right of Texans to receive any content that might be posted online anywhere in the world. But there are laws in other countries that actually, make things like Holocaust denial illegal. And so platforms actually are legally obligated to remove that content under German law, but that could violate HB20. And that just doesn't make sense. I would also say additionally, one of the things that people, particularly on discussions on Twitter and elsewhere, legal experts, a lot of people were like, well, they should just block Texas, just don't offer services to Texas. Well, the Texas law would actually, appear on its face to prevent that, because it does say that, you can't block a Texan from participating based on their location. So, there are just numerous problems with the law. And I think ultimately, if courts dig into the issues, they will see that these problems just don't allow the law to stand.
And there's a message here from Gary Bledsoe in the chat that I think addresses some of these questions. There were other amicus briefs filed. Elizabeth, I don't know if you can see Gary's questions, if there's anything else there you want to address.
Yes, I have a few answers to those. Yes, there were other amicus briefs filed, a number of groups filed. The Center for Democracy and Technology, along with the Electronic Frontier Foundation, filed a brief. The Copia Institute, the Reporters Committee. I know I'm forgetting people. Oh, great. Thank you, Robert. He just put in the full list. The district court judge was Judge Pittman. And on the panel, I'm going to ask if Robert or someone else, I know Judge Edith Jones, Judge Southwick, and
Oldham,
pardon?
Judge Oldham.
Okay, great. Thank you. And then I'm looking at the decision to lift the injunction was not unanimous. It was a 2-to-1 decision. And as I said, in terms of the implications for interstate commerce, obviously the way the Texas law is written, it attempts to control the behavior of companies, no matter where they operate, and that is certainly far beyond the power that Texas has as a state under the U.S. Constitution.
Great. Let me open it again. Other questions from journalists on the call?
Hi, this is Lauren Feiner with CNBC. I was wondering, to what extent did you consider perhaps not taking this step at this time? And, how did you think through the possibility that the court could rule in a way that's unfavorable to what you're seeking?
Well, I think it's important just to clarify our role. So as Chamber of Progress, we are involved in the case as amici. So we're supporting the parties to the litigation, Net Choice and CCIA, which it brought this constitutional challenge. And we know they gave careful consideration to their options. We think it's incredibly important, and that an emergency application really was necessary because of the implications of HB20 going into effect. It's really impossible for providers to comply with. I was explaining these conflict of law type problems. There's no way to change their operations to really come into compliance, and certainly not on an immediate time frame. And so I think getting relief so that we can continue the litigation just makes a lot of sense. And I think as amici, Chamber of Progress and the other organizations that joined us felt it was really important to get a filing in to make sure that the court understands really the implications, the practical implications of what HB20 does. And I think Carlos did a great job about making that really real and specific, and that was what we were trying to do in our filing.
Great. Next question from journalists.
A question for Representative Rosenthal. How much do you think that this law it will be a lasting, priority for the party, or is it do you think it's just a temporary priority due to the attention because of President Trump's ban from Twitter and the overall feelings of culture war cancellation and stuff like that?
It's a very good question. And I felt like at the time that the law being passed was really in preparation for what was anticipated to be a very extremely partisan primary process that we're seeing play out right now. So it's a good question, because now that process is done and the districts have been drawn and the selections have been made, is it really going to be an important priority as far as a talking point for them? Because the legal mind, I'm an engineer, I'm not a lawyer, but the legal minds on this call are pointing out difficulties with enforcement of this kind of thing. So is it something they really want to, continue to champion, even though it's unenforceable? It's a very good question. I hope not, but these things are hard to predict.
Great. Other questions from journalists online? Maybe a last word here. So with that, let me say thank you to all of those in attendance, as well as a big thank you to our speakers, Representative Rosenthal, for your leadership on this issue, Carlos Gutierrez for speaking about the impact that this will have on marginalized communities and dealing with aggressive hate speech against those communities, and Elizabeth Banker for providing us the legal perspective. The story isn't over yet. We'll be continuing to work on this important case, as are, I think, a number of organizations on the call. So stay tuned. Thanks, everybody, for joining us. We really appreciate it. We'll talk soon. Bye-bye.